Are you a family caregiver? Are you caregiving for someone who can no longer take care of themselves? Are you overwhelmed? This is Caregiver Solutions Info with Marcia Teele. Marcia will be hosting an hour of true stories and information, tips and updates of the latest research and necessary information in the caregiving field, focusing on you, the family caregiver. An Alzheimer's disease and dementia care expert, Marcia has 15 years of hands-on experience at Arden Courts, a leader in assisted living dementia communities here in the U.S. Marcia covers everything you need to know as a family caregiver, especially if you care for a loved one with Alzheimer's disease or other related dementia or chronic illness. If you have a friend or relative that is also a family caregiver, call them now. They won't want to miss a minute. And let them know they can watch on caregiversolutions.info. And they can listen on WNN 1470 AM in South Florida or nationally on the iHeartRadio app. Now, sit back, relax, and learn from our host, Marcia Teele, as she brings information to you that may just be the caregiving solution you need.
Hi, everyone, and welcome to Caregiver Solutions Info. I'm glad you could join us this evening. I'm so happy that you're here because this show is for you, the family caregiver. This is the program where we ask the questions and you get the answers from experts in the field. Dealing with caregiving, Alzheimer's, dementia, whatever you need, we hope that you'll find answers here. So sit back and relax because we have a full hour of great information for you today. If you hear something that you want to comment about or you have an idea of a topic that you'd like us to cover, you can contact me. My email address is delray@arden-courts.com. Again, that's delray@arden, ARDEN-courts, COURTS.com. So I want to welcome you to please feel free to send me a message. We'd love to get your feedback and help you in any way that we can. So today I'm very excited. We are, of course, here live again from Boca Raton, Florida. And we have with us by popular demand back special certified, board certified elder law attorney Heidi Friedman. Hi, Heidi.
Hi, Marcia. Thank you for having me here again.
Well, I'm so happy because, you've been on the show before, and we've gotten so many good comments about the things that people have learned from the information that you give, and you are just so welcome in the community because people that are in the professional field, they like to not only share their expertise, but when it comes to caregiving, I think it's even more important because people don't really have too much access directly with attorneys. And when you're dealing with caregiving and dementia and you have different paths to travel, I think it's very important to be prepared. And, of course, that's what we do. We want to make sure people are prepared and that they know what is coming down the path so there's no surprises.
Right, exactly. Being prepared is the best thing to do.
Yes. So my first thing, I want to congratulate you because I know that you are now a board-certified elder law attorney.
Yes.
And just for the record, explain to everybody what's the difference between an elder law attorney and a board-certified elder law attorney.
Well, under the Florida regulations, in different fields of the legal world, you can become board certified, which basically means that you have to take another test strictly within your specialty. And it's a more difficult test. And when I took it this time, there was only a 50% pass rate.
Wow.
There's only 108 board-certified elder law attorneys in the state of Florida. And I actually am proud to say that I passed it on my first time.
Congratulations.
So that was really very exciting. But it basically means that the Florida bar has declared me or is now allow me to say that I am an expert in this field as a board-certified attorney.
So if you're going to go to an elder law attorney, why not go to a board-certified elder law attorney?
Exactly. It is. And board certified is just a way that that somebody really knows what they're doing in their field, just like you would want to go to a board-certified doctor or, it's just a higher level of certification from my governing body.
It makes sense. It really does. I know people that are having surgeries, and they go and check out the history and the background of the surgeons. And, of course, they want someone who is board certified in their field, and they want somebody who has done that particular procedure many, many, many times.
Exactly.
Because experience does make a difference.
And one of the things about the board certification for elder law, it's a little bit more of a difficult test than some of the other legal specialties, and that's because it doesn't just encompass what I do, the planning that I do. Elder law is very wide-reaching. It deals with guardianships. It deals with wills and trusts. It deals with Medicaid and VA planning, elder abuse. So it's a gamut of things. So to be board certified is really I'm very impressed and very excited that I was able to pass that test.
Yeah, that's great, because you can actually help people in all different aspects of elder law and not just one thing. So you can, and matter of fact, I know a lot of the fields within elder law, they kind of cross over. The
Yes.
things that you just explained about the guardianships and estate planning and all of that, they do get commingled, and you really need to know the consequences and the pros and cons of doing everything within that scope.
Yes, exactly. And, I might not know everything about guardianship, but I know enough to know either that I can handle it or that I need to refer it out to another elder law attorney or another attorney that does more litigation portion. So it's important as an elder law attorney to know the whole scope of when you're dealing with a client.
That's right.
Of all the different pieces.
That's right. So I want to start off today by putting something out there, an idea out there that I think is pretty prevalent among people, and then you're going to tell me what you think about this.
Okay.
So when people hear about estate planning, I think a lot of people think about the word estate as having lots of money, a lot of property, a lot of stocks, very complicated personal profile, and they feel that, well, if I don't have that, if I don't have an estate that it's complicated, I don't need to do estate planning. And I think that is like a common fallacy among people. Do you hear that?
I do hear that, and unfortunately it is a very big misconception, because in truth, the smaller estate that you have, the more that you want to make sure that you do the proper estate planning, because if not, Marcia, when you die, there is only certain ways to get your money from your estate to your heirs. The worst way is to die without any kind of plan, because what happens at that point is now your loved ones have to go through a probate, and probates can be long and drawn out.
And it's different in every state, right?
It is different in every state. So in the state of Florida, there's there's a summary administration and there's a typical administration. You have to notify creditors. It's a long process. And the problem is, if you die without any kind of planning, at the end of the day, it is the Florida statutes that make the determination of where your money goes. Where does your property go? It's dying intestate. Now, if you die with just a will, which a lot of people think that that's enough.
Right.
That's a little bit better, but where there's a will, there's a probate. And again, you want to try to avoid a probate, because probate is a long, drawn-out procedure.
And it's costly, right?
It can be very costly. You do need to have attorneys to be able to deal with it. There are attorneys that specialize in that. I don't. But there are attorneys that deal strictly with probate.
Which tells us that there are a lot of people that die without estate planning.
There is a lot of people that die without estate planning or without proper estate planning. And, again, if you have a will, the good thing about that is now you've told the court after probate where you want your money to go to. But there are other ways, if you do the proper planning, that you don't have to go through probate. And that's kind of part of what we do as an elder law attorney. When I do other planning, I try to incorporate estate planning as well, so that my clients do not need to go through probate, that they are able to die and know that their assets aren't being chipped away by another attorney, but they're going to go directly to their heirs.
I think it makes things less complicated,
definitely
less costly, and it probably gives families more peace of mind knowing that they never have to worry about it once it's done.
Yes, and that's true. And, a lot of what people don't understand also is that in the elder community, when you turn a certain age, your estate plan, if you've done your estate plan when you were in your 40s or your 50 and you have younger children, your thought process at that point is to make sure that when you die, your spouse has enough money to continue for your children and to continue maybe education or taking care of them. Your dependents.
Mm-hmm.
But when you start to reach 65 and 70, it's a different type of estate planning that needs to be done.
So do people have to redo it all?
Yes. Well, either that or they at least need to do an amendment to some of their stuff that they've done.
Because their life situation has changed.
Their life situation has changed.
And the kids have grown up.
Yes.
Maybe they're on their own. They don't need you to take care of them anymore.
That's correct.
Hopefully, if you've raised your children right, they've left the nest.
I'm trying.
They've left the nest. They've flown away, and you don't have to worry because you taught them how to make a living and take care of themselves. But sometimes life happens, and even when you're older, you still might have dependence because sometimes things happen medical and that are unforeseen circumstances.
Right. But the biggest problem that I see when I see married couples that come to me and they're in their 65 or 70 is that they have your typical estate plan, which is, I love you estate plan. I'm going to leave when I die. I leave everything to my beloved.
I love you.
I'm going to leave everything to each other. Well, the problem is if we do proper planning for them and we get them government benefits to help pay for that long-term care, because part of what we do is get either Medicaid and or VA benefits. If I have a well spouse who has the assets now and a sick spouse who is on government programs and the well spouse dies first, the problem is now all those assets go to the sick spouse. So you need to do the proper planning that can be done between a husband and wife. It's called a qualifying special needs trust.
So it's very interesting that you said that because if the I love you, I like how you call that, but the I love you plan where everything goes, you don't think about the consequences because you think you're doing the right thing.
Right.
And in essence, it could actually be detrimental to the whole situation.
To the whole plan.
So
exactly.
I think the idea is for an elder law attorney, I think what people would get out of it is seeing the big picture.
Right.
And looking at different scenarios, looking at your life now and in the future of what things might happen and being prepared, that's the key word, is being prepared for whatever way your life takes you so that you're going to be prepared to continue to have things distributed the way you want to continue to take care of people the way you want to, and to not, be stressed out about it.
And the most important thing is to try to have your assets outlive your life. I mean, that's a big goal, is that, unfortunately, people are getting sicker younger, or they're living longer, and they're living longer with illnesses that are still costing a lot of money. So you want to make sure that whatever assets you've been able to accumulate during your lifetime will now be able to outlast your life. They won't run out. And that's part of the planning.
You just brought an example to my mind. I recently met a gentleman who was very, very successful in business and ran a huge company, multiple companies actually, and he was very, very successful. And unfortunately, he had a wife that needed open heart surgery, and she needed 2 open heart surgeries, and there was a minimum of $500,000 a piece plus everything else that it cost.
Right.
And for whatever reason, I didn't get into the details, but whatever reason, there was no insurance. This poor situation happened, and now the man, of course, is struggling, having to work at a later age to take care of himself. Because he lost all of that. Now, I don't know why they couldn't get insurance, but again, these are things that we don't foresee.
Right.
And so I think that we need to be prepared and look at what could happen. I mean, same thing with caregivers with Alzheimer's. No one expects that their spouse is going to get Alzheimer's.
Right.
But it does happen. And everyone, of course, is shocked because it's nothing that we would ever expect or would want to happen. But now the reality hits. It's here. What are we going to do about it? How are we going to be prepared? What do we need to do going forward?
And not only that, what are you going to do if you die first? How are you going to make sure that your spouse who has Alzheimer's or is in need of care is still taken care of even if you happen to die first?
That's true. And when we come back from our first commercial break, we're going to talk about how we do that. And we have the expert here, Heidi Friedman. So stay with us. We'll be right back.
Arden Courts is not just a place to live. It's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides.
Feelings of depression, isolation, and frustration are common among persons living with Alzheimer's or related dementias. It's common among those who care for them, too. It takes a lot of patience and courage. It also takes knowing when you can no longer do it alone. At Arden Courts, memory care is all we do. Talk to us. We know. We understand. We can help. Don't let guilt keep you from making the right decision. Visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost.
You are listening to your host, Marcia Teele, an Alzheimer's disease and dementia care expert on CareGiverSolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Hi, and we are back with Caregiver Solutions Info. Thank you for being with us today, whether you are listening on the local radio here in South Florida or whether you're watching us on your computer on the website, caregiversolutions.info. I'm glad that you're joining us. I'd like to thank our national sponsor, Arden Courts Memory Care Community, for making this show possible. Arden Courts has over 52 communities across the United States, and every one of them is designed specifically to take care of people with Alzheimer's and other related dementia. They are an expert in the field because they have put in the time and attention and whatever it takes to make it a wonderful place for your loved one to be happy, safe, and healthy and have quality of life and elevate their self-esteem and give you peace of mind. And so if you hear something on the commercial, give Arden Courts a call. And you might want to give them a call because they are offering to you a free book. This is called The 36-Hour Day, and it's a caregiving book. It's an excellent book, and it can be yours just for the asking. Arden Courts would like to offer this to you free by calling their toll-free number, which is 888-478-2410. Tell them that you heard about the offer on the Caregiver Solutions Info program. They'll get your name and your address, and they'll be happy to mail one out to you. This book is invaluable to the family caregiver. It explains the differences between the different kinds of dementia. It has wonderful tips about how to take care of different issues and challenges that come with caregiving for someone with memory loss, and I think you'll really find it beneficial. So call Arden Courts at 888-478-2410 and get your free book, The 36-Hour Day. So I'm here with board-certified elder law attorney Heidi Friedman, and welcome back, Heidi.
Thank you.
We love Heidi. She is so knowledgeable in the field of elder law, and we're talking about estate planning today. And we're talking about why it's important for everyone to have an estate plan, even if you feel that you have a small amount of money and maybe not even any property, but you need to plan for the future, and you don't want to leave a mess in essence,
right,
for your heirs to deal with if you die without a plan. It just makes things complicated. So we're talking about who needs to have an estate plan, and we're talking about the kinds of things that an elder law attorney can help you with. And before commercial break, we mentioned about how do you deal with the fact that if you are a spouse and your other spouse has Alzheimer's, now it kind of changes things because you're the caregiver, you're the primary caregiver, and you want to be sure you're going to be there and be able to provide for that unwell spouse. And what happens if you die first, what's going to happen to them? So is this all part of an estate planning that someone would do, Heidi?
Yes, it's part of an estate planning that an elder law attorney would do. When you're dealing with estate lawyers, understand that they're a little bit different and their philosophies are different. Most estate lawyers, I can't say all of them, but most estate lawyers are dealing a lot with what happens at death, and that's kind of where their focus is. Unlike an elder law attorney, who we're dealing more with what's going to happen during those years between now and getting you to the death. I mean, I hate to say it that way, but that's really and truly where we're at. And what happens if you or your loved one gets sick? How are you going to afford to pay for that long-term care? Do you have long-term care insurance? Have you set up the proper estate plan? Have you done the proper documents, the proper incapacity documents, the durable power of attorney, the health care directives, so that if something does happen that, you have chosen who you want to act on your behalf, whether it's regarding your finances or regarding your health care decisions, so that a guardianship might not be necessary. Because anything that you don't prepare for, if it happens, it becomes extremely costly. And the goal is try to preserve as much of your assets as possible, because we all know that good care is costly.
Right, right. So sometimes if we don't prepare, it's too late to go back and do something. Isn't that true?
Yes, it's very true. I mean, if I have had clients who have come to me where their loved one has gotten so far into the Alzheimer's disease where they no longer recognize them, or they no longer have any idea, what's going on, and they're lacking that capacity to be able to sign documents. And they've done a durable power of attorney, but they did it 10 years ago or 7 years ago, and they needed to be updated and they didn't. I mean, that's the other misconception that a lot of people have is, I did my estate plan, 15 years ago, I'm good.
So why is it important to go back and look at this, and what time frame would you recommend that someone review their documents?
It's really an important thing to go back and look at your documents because, number one, statutes changed. The laws changed. As a matter of fact, in 2011, the Florida statutes changed regarding durable powers of attorney. Now, while there are exceptions for durable powers of attorney that were in effect before then, obviously, there are new laws for the durable powers of attorney that came out after 2011, which include a certain, they call them, separate sign enumerated powers. There are special powers.
So it's an enhanced document.
It's an enhanced document. There's also certain things that you can't do anymore. Like we used to be able to do springing durable powers of attorney, which said my durable power of attorney doesn't go into effect until and unless I'm declared incapacitated. You're no longer allowed to do that anymore. Now the durable powers of attorney go into effect the day you sign them. So it's really important that you make sure your documents are updated. And my recommendation would be to make sure that you have an attorney look at them probably every 4 to 5 years.
Wow, that often?
That often. And again, also the estate plan should be updated based on your life changes. I mean, when I have little children right now, my estate planning is much different than the planning I would do for my parents who are in their 70s.
Right.
So, things change and your documents need to change.
Right. So I have a question. People ask me this a lot. If they have a durable power of attorney that they had executed, let's say 10 years ago, and they don't have it up to date with the new, within the laws of whatever state they're in, is that power of attorney still good? Is it still worth something? Can it still be used?
Yes, it can be still used as long as the agent hasn't retracted it or done a new durable power of attorney. The problem is in the state of Florida, and I can't talk about other states, but in the state of Florida, your durable power of attorney is only as good as the powers that are in them. You can no longer do a durable power of attorney that says, I give Marcia, my agent, the right to do anything that I can do.
You're not going to give me that?
I could, but it won't work.
You can trust me.
I can trust you. But, you can't do that anymore. Now the powers have to actually be enumerated inside the document.
So in other words, not so general.
You cannot do a broad durable power of attorney anymore.
Mm-hmm.
And again, the superpowers that we like to call them, or special powers or enumerated powers, they in fact have to be initialed. Each one of them have to be initialed. So it's not even, you can't even just do a durable power of attorney, have those powers in them and sign it at the end.
What about people who think they're going to bypass some legal stuff and save a lot of money, and they go to an office supply store.
Yeah.
All right?
It's my worst nightmare.
And they buy a form that says power of attorney, and they just fill in the blanks and say, okay, I have power of attorney. What's the problem with that? Because, there are people that do that.
Yes, and LegalZoom and those other kind of online creative powers. The problem with them is that, first of all, they might not be effective. It depends on how there is a statute. You have to follow the statute. If the durable power of attorney isn't signed with 2 witnesses and a notary, it's not effective. The other part is, again, like I said, those superpowers. If they're not initialed, each one of them initialed, they are not effective. So here's where the problem comes in, Marcia. If I have a client that comes in with one of those documents, and believe me, I've had plenty of them that have done that, and their loved one is no longer capacitated, but this is the document. This is the document I've had my loved one create. The problem is that if it doesn't follow the Florida statute, it's not in effect, so it can't be used. So what happens at that point is you've saved, it's like that penny wise, pound foolish. You've saved a lot of money in the beginning, but now you're looking at guardianship, and guardianships are expensive, and they can create a lot of contention within the family, and a lot of, now you have to declare your loved one to be incapacitated, remove rights, go through a court proceeding. You have to be represented by an attorney. Your loved one has to be represented by an attorney. So it's not saving you anything in the end. Right.
And also, those simple pieces of paper, and they are simple.
Yes.
There's some of them are one-pagers.
Yes.
And I've seen some of your durable power of attorneys that you do, and they're probably like 30 pages, some of them.
Approximately.
Yeah. So, you're getting a lot more when you have someone who's an expert at doing it. But they're so simple that they don't even allow you to do a whole lot. So they're, like you said, ineffective because they don't express what a person can do or what they can't do. And so it could be actually useless in many ways.
Absolutely. It could be useless. And again, if, for example, one of the things that our durable power of attorney does, it allows our agents to self-deal. And what that means is that self-deal.
Self-deal, like means, in poker?
Yeah, kind of. You get to win on both sides. You get to be at the both ends of the stick and win. I don't know. All
right. So explain what that means.
You kind of get to. So normally when I do a durable power of attorney, I can't enter into any kind of agreement or any kind of contract with my principal, because I'm the agent, where I benefit.
But so I'm the principal.
You're the principal.
I'm giving you my power.
Right. I can't now enter into a contract with you, signing on your behalf and me, where I'm going to actually make money.
Benefit from.
Where I'm going to benefit. But my durable power of attorney allows that. And the reason why is because when you get to a certain point and you need certain planning, that might need to be done. I might need to sign on your behalf and have me as your family member benefit so that I can remove assets from you and qualify you for government benefits. So again, durable powers of attorney it's one of the most important documents that anybody over the age of 18 should have. It should be taken very seriously.
And you said 18,
not
I did say
80. 18. No, I said over 18.
And explain why 18.
Because if you once you turn 18, you're an adult.
Right.
So if you have any assets or anything in your own name,
like a car,
a bank account, you're in school, you're in college. I just did one for a college age student because he's going to college, and without a durable power of attorney, his parents can't really act on his behalf anymore.
So your parents no longer have power to sign for you or do anything on your behalf without this legal durable power of attorney once you turn 18 years old.
Once you turn 18 years old.
And I would go out on a limb and say that I doubt many people understand that.
Many people don't understand that. And the other thing that many people don't understand is when you turn 18 years old and you go to college and you're out there, if your parents don't have a health care directive, again, there's a lot of times that hospitals will not even, if God forbid something happens to your college day student, or you try to call on the phone and get information about them, they won't give it to you.
Yeah.
It's really
important. And I think
this
is important. We're talking about caregiving, and caregivers come in all sizes, shapes, and ages. And so this topic of conversation is beneficial, because maybe you're a caregiver out there listening today, but maybe you have a grandchild who turned 18, who's a young adult, and they don't have these documents. And so this is important it's a family matter to take care of these types of things. And so, no matter who we are and how old we are, we all need to know about this and take action.
And one of the most important things that I think married couples need to know, just because you're married does not mean you can act on your spouse's financial accounts. So if you have a spouse who has an IRA or has an account in their own name, just because you're married does not mean that you can now act on his or her behalf on that account. You have to have the durable power of attorney, and a lot of married couples do not understand that. They're like, I'm married to him. Why can't I do whatever I need to do with his account? And you can't.
Right.
So it's really important.
One thing that I also have come across, people think that because they have power of attorney at a bank to sign a check for somebody through the bank, that they're allowed to sign checks and, pay bills. They think that that is a full, across the board vehicle to use for anything. And I said, no, did you sign this at the bank? Yes. Is it for this account? Yes. Well, that is only for that account. That doesn't cover anything else.
Exactly.
And people don't understand that also sometimes, that that's why we call it a durable power of attorney. It's a legal document. It's not just something that you sign at the bank allowing you to co-sign checks.
Exactly.
Mm-hmm.
I mean, and again, it goes back to what I said in the beginning, that the durable power of attorney is only as good as the powers that are in it.
Right.
And if you're signing something with the bank that allows you to act as a power of attorney on a bank account, that's where it begins and ends.
Right. Yeah, that's it.
Yeah.
Very, very important for people to know.
It is.
And I think a lot of people do have legal documents, but we're getting into the nitty-gritty today, and that's why we want to talk about these superpowers, because it's fairly new in the last several years.
It is.
And a lot of people haven't gone back and dug their legal documents out of their safe or their file cabinet or wherever they keep them to make sure that they are up to date and they do include everything they need to have. So we're going to take our second commercial break, and when we come back, Heidi's going to share what are some of these, she calls them superpowers, that we need to know. And she's going to go into detail about them and explain why they're important. So we'll be right back. Stay with us.
Feelings of depression, isolation, and frustration are common among persons living with Alzheimer's or related dementias. It's common among those who care for them, too. It takes a lot of patience and courage. It also takes knowing when you can no longer do it alone. At Arden Courts, memory care is all we do. Talk to us. We know. We understand. We can help. Don't let guilt keep you from making the right decision. Visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Being unable to recognize the obvious often occurs with Alzheimer's or related dementias, even among their caregivers. When the time comes for you to decide that someone you love needs more help than you can give, will you be able to recognize it? Don't wait for a crisis to make the decision for you. Talk to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines. Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know. We understand. We can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines.
You are listening to your host, Marcia Teele, an Alzheimer's disease and dementia care expert on CareGiverSolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
We are here in the studio in Boca Raton, Florida, with Heidi Freeman, board-certified elder law attorney. Heidi, we're talking about superpowers now, about durable power of attorneys that are now enhanced by Florida statute. So could you please explain what some of these superpowers are and why they've been included as an update and why they're important?
Well, if you look at the superpowers, and I will go through them, but if you look at them, they really deal a lot with somebody's estate planning. Now, when you do a will or a trust or something, you're supposed to have capacity, and it's a different kind of capacity than just signing a durable power of attorney. You need to have what's called, capacity to be able, testamentary capacity is what it's called. You have to have the capacity to know what you're doing and where you're distributing your assets to upon your death. But if you look at these enumerated superpowers, is what I like to call them, they actually deal in that same arena. They allow now your agent to kind of step in there and do some estate planning, even though the statute specifically says that the agent is supposed to do as much as possible to keep your estate desires intact. But if you look at the superpowers, like the first one is that the agent can create an inter vivus or vivus trust, which basically is a trust during your lifetime. So in creating a trust is basically an estate plan. When I create a trust, included in my trust is what's going to happen to me while I'm alive and my assets while I'm alive and what's going to happen when I die. So estate planning can be changed with that. The second one is, to go in there and change a trust that's already been created for you. But the trick here is if it's an older trust and it hasn't said that an agent can change that trust, then the agent can't. So it needs to be a trust that actually incorporates the ability for a durable power of attorney or an agent to be able to go in there and do some amendments.
And are we talking about a revocable trust versus an irrevocable trust? Yes,
we're definitely talking about a revocable trust.
Yes.
When you're dealing with an irrevocable trust, that they're basically
irrevocable
and not changeable. I mean, there are ways to get around that, but it's mostly through a court, or you have to have a certain, clause in there that allows for an independent trustee.
And there are situations that call for one or the other.
Absolutely.
Okay.
Absolutely. We use both in our practice. It depends on what we're looking to do, what benefits are we looking to go for.
And this is part of the planning process, to look at the big picture. So when someone, I'm going to kind of go down another path for a second, because you brought up a good point, because what vehicles do people need to use? And just as an example, we have a revocable trust and irrevocable trust. They're both used, but you have to know when one is better than the other. So when someone comes to you, I imagine you're really getting into all the detail about their family, their relationships, not just the financial part, but you're talking about relationships.
Absolutely.
Are there extended situations? Are there extended medical complications? Are there stepchildren involved? Or is this a second marriage? Or a third, or a fourth.
Right. I've had a few of those.
Whatever, because those are complicated.
Absolutely.
I mean, people get married and, they start another family and they have multiple families and things are peachy keen. But when, life goes on and now time comes for asset distributions and, it can be very not only complicated, but very emotionally hard for families when things haven't been set up the way that things were probably intended.
Right. And unfortunately can cause a lot of family discourse.
Yes.
So when people die, I hate to say it, but money does change people, and family members who might have been close at one point now become, mortal enemies, and they're fighting over, just almost ridiculous things. But somebody who sets up a good estate plan and has talked to their family members, that's another piece about it. If you're going to set up an estate plan and have it hidden, you're going to expect that there's going to be issues upon your death. There's a reason why you're kind of hiding it. And I understand that there are reasons for that. Mm-hmm. But, you don't
want to just find yourself one day going around a curve and no brakes in
your
car because someone knows what your estate plan says, right?
It's true. But, again, I think that the open conversation is a difficult conversation to have in a family member. Regardless if somebody's sick or not sick, what should I do upon death? And, I had in my own family, one of the members of my family, who will remain nameless, did not want to do, he kept thinking, if I do a will, I'm going to die the next day. I mean, it was kind of a little bit
superstitious
type thing, but it's a really important thing and an important discussion that you have to have with your family. I mean, it really is.
One thing before I forget, I want to go back to something you said earlier, and then we'll go back to the superpowers while it's still on my brain. Talking about durable power of attorney, and I think you said that durable power of attorney used to only be in effect if the person was deemed incompetent, but now with the revised law, once you sign a durable power of attorney, it is effective and someone can use it.
Exactly. And actually, let me correct that. What I said is that it used to be that we would have springing durable powers of attorney, which meant that you could set up a durable power of attorney. It's kind of interesting. You could set up a durable power of attorney that said that this document does not become effective until I become incapacitated.
Right.
Now it becomes effective as soon as you sign it.
So that being said, that's
yes.
what I heard you say. So that caused me to think when you said people hide things. If someone, let's say you're a mom or a dad, and you want to give power of attorney to an adult child, but you really don't want them to know that they have ability to make decisions and do things in your name because they do have this power. So you want to hide that because you're maybe afraid, even though I guess you have to trust them enough in the first place to be able to give them that power, but you don't want them to know about it until they have to use it. So in that case, wouldn't somebody maybe want to hide the fact that they've given their adult child the durable power of attorney?
Okay, so it's very interesting that you should ask that, because I got asked that at a seminar, and here was my response back to her. If you do not trust your children to have this power while you're capacitated, what in the world would make you trust them to have this power when you're not capacitated? So if you have concerns about who you're putting down as your durable power of attorney because you don't trust them, what makes you think they're going to do any better now that you are out of it?
Right.
And now they have total
control. And they
control.
can really take advantage.
Yeah, the durable power, again, it's a very powerful document because it does allow somebody to step into your shoes and act
at any time.
At any time for you. Now, there is a fiduciary
to
duty.
You sometimes
too.
Yeah,
but there is a fiduciary duty within the statute that you need to do it on the best interest of your principal. Now, here's the difference. I wanted to also say one thing. The durable power of attorney, and I get this a lot, well, I've given my son or I've given my daughter durable power of attorney, so I have no rights anymore. That is not the case. You still maintain your right. It's just that you're allowing somebody else to also act for you.
Right. Let's say you go on a trip and you're out of the country and you're in Australia and there's an urgent matter at home. You can't be there to sign.
Right.
So then your agent can sign for you.
Exactly. So you don't lose your rights. Unlike guardianship, where you would actually, those rights are actually removed from you. In a durable power of attorney, you maintain your rights, but you're allowing that child. But again, if you're choosing somebody that you're concerned about, that's not the person to put in there.
So you want to tell them, look, I've named you as my power of attorney. If something happens to me, then I trust you to do what you need to do.
Right.
How I've laid it out in my estate plan or from our conversations to do the right thing.
Right. Although sometimes, again, with the planning, the estate plan isn't going to work. So, when somebody comes into my office, we do a whole assessment. Yes, I can tell you that my planning strategies and the trust and everything, they're not cookie cutter, but they're standard things that you're going to put into everything.
Standard things that you need to have
in everything,
that
right?
You need to have, yeah.
But the plan, the dynamics in the family, the financial pieces,
that changes.
That all comes together. Right.
That's the custom part.
Right. That's where everything gets customized, and you have to really know what you're doing in order to take care of the whole piece, not just the one little part.
Right.
Because everything does kind of affect the other.
That's true. It gets complicated.
It does.
Yeah. So let's go back to the superpower, the next one, and talk about that one.
The next one is make a gift subject to, the gifting that you're allowed to do under the IRS. And this is another thing that people tend to get very confused. People will come to me and say, oh, wait, can I gift away $14,000 to one person for, a year and I'm fine, whether it's for Medicaid purposes or VA purposes or anything. And basically what that gift is in the state, federally, we all have a 5.35 or 5.45 estate and inheritance exemption for taxes. The $14,000 is for really, really very wealthy people who have a lot more than that, and they want to give away $14,000 to a lot of different people in the year, so it reduces how much money they're going to give or leave upon death, because $14,000 to an individual does not trigger a gift tax.
Did it used to be $10,000?
Yes,
not too long ago.
Now it's 14.
Okay,
yes.
I remember.
So you don't have to file a gift tax return, and you don't have to notify anybody. So I can give away $14,000. If I have millions and millions and millions, I can give away $14,000 to everybody, and nobody knows the wiser. If I give away more than 14, I have to file a gift tax return. Mm-hmm. So that's kind of what this is saying, that superpower is, and it's really for the very wealthy, that my agent could continue to give away $14,000 to as many people
every year.
Every year. So that's that one. We have our clients initial it, but most of the time it doesn't even go into, it's nothing. It doesn't mean anything.
But it's interesting how that value has changed, because it's been $10,000 for the longest time.
Then I think it was 12 at one point, and now it's 14.
Yeah, so as inflation, everything else changes, and interest changes, everything goes up. We're going to take our last commercial break. When we come back, more superpower info from elder law attorney Heidi Friedman.
Somewhere at the corner of bewildered and confused is a lost mother, a father, a sibling, a grandparent. Wandering is a common symptom of Alzheimer's or related dementias, and can often make those who care for a loved one feel just as lost. If you're looking for a place that's safe and secure, look to Arden Courts. Memory care is all we do. We know, we understand, we can help. To learn more, visit arden-courts.com. Arden Courts follows equal housing opportunity guidelines.
Arden Courts is not just a place to live. It's a place to call home. Residential living combined with quality caregiving. This is the philosophy behind Arden Courts. Communities created exclusively for individuals with Alzheimer's disease and related dementia who would benefit from a safe and structured environment. For additional information about any of the unique services Arden Courts provides, call 888-478-2410 to locate a community nearest you. Inquire about our educational seminars, resource library, or support groups, or simply feel free to ask questions you may have about Alzheimer's and related dementias. At Arden Courts, we know, we understand, and we can help, because memory care is all we do. Remember, call 888-478-2410 for additional information about any of the unique services Arden Courts provides. You are listening to your host, Marcia Teele, an Alzheimer's disease and dementia care expert on CareGiverSolutions.info. If you have a question or wish to share a story, call into the show at 888-565-1470 and talk with Marcia. Now, back to Caregiver Solutions.
Welcome back. I'm glad you're with us. We are talking about superpowers, and it's not Superman or Batman or any of the superheroes, but I do have a superhero with me today. Her name is Heidi Friedman. She is a board-certified elder law attorney with the Elder Law Department, and she is here, and we're talking about superpowers within durable power of attorneys, legal documents that everyone needs to have as part of an estate plan. So let's get back to a couple more of the superpowers. We have a few more to discuss.
Yeah, and these are some of the really important ones. Create or change right of survivorship. What a lot of people don't understand is how you own property. There's different ways to own a property. There's tenants by the entireties. There's joint tenants with right of survivorship. There's tenants in common. So what that particular superpower allows you to do is to change the way your principal owns a property.
And why would that be important to change it once it's set up initially? Is it because of maybe there's been a divorce or a death in the family and you need to change it because of that?
Usually what happens is when you do a bank account, or if you're not married at the time you purchase property together, you might own it as tenants in the common, and now you need to have it as joint tenants with right of survivorship. The difference between those two is tenants in common. If you and I own a property together, I own a portion of it, you own a portion of it. then when you die, it goes through your estate plan. When I die, it goes through my estate plan. If we own it as joint tenants with the right of survivorship, if I die, it goes to you. If you die, it
then
goes
it's
to
all
me.
mine, or
Right.
it's all yours.
It's all mine.
So that's
or all
important.
Yours.
I mean,
Very
people
important.
need to know the dimension, the consequences of setting something up one way or the other. And if they did set it up wrong, the superpower allows them to make that change.
Allows them to change it.
Okay, that's good.
And the next one is create or change a beneficiary designation. We happen to use this a lot because, again, if I have a married couple and, an IRA is the beneficiary is the spouse, which normally is what happens, or, they've set up a bank account where the beneficiary is the spouse, and now the spouse is on government benefits and is sick, we don't want that anymore. So we need to be able to change those beneficiaries. Or, sometimes parents are sick, and you just want to be able to have that ability.
So if someone didn't have the updated durable power of attorney with the superpowers that included that ability to change the beneficiary, and let's say they did have the IRA that goes to the spouse, and that now spouse is sick and needs to go on Medicaid, that could mess up that whole plan, couldn't it?
Absolutely.
And
we'd have to do different kinds of planning to try to get around that.
Okay.
So, besides it just now being just like a quick change, now we'd have to do a whole different estate plan to try to fix that. I mean, it would it could be a little bit more difficult.
So these superpowers are actually good things that everybody needs to have because it makes things easier.
Right, but also understand some of them you don't want to have signed. So I had a family. It was a mom and her son and the daughter, and she had left everything to the daughter, and she didn't want, for some reason, the son to be able to have the power to change the beneficiaries. Because again, when you have a power to change the beneficiary, that means that if I've left something to you and you have the power to change that beneficiary to somebody else, you would be able to do that. So we just didn't initial that superpower. Okay. So it was her durable power of attorney, but did not have that ability.
So it's in there, but as long as it's not initialed, it's not effective.
Exactly. So he was not able to change beneficiaries.
So it's sort of like a menu. I mean, it's like an a la carte, really.
Yes.
And you're looking at the menu, and I'll have this and this, but I don't want that and that.
Exactly.
And
yes.
you have the ability to pick and choose.
Right. Now,
I love that.
Sometimes I'll get a durable power of attorney that's been either again, done by an attorney that might not understand elder law, or it's one of those documents that somebody's pulled up and they haven't initialed everything, and I needed the one initialed that's not initialed. So sometimes that's a bigger problem also. So, you still have the durable power of attorney not done correctly and can still create issues.
Wow.
Then, there's also the right for the agent to waive a principal's right to benefit on a joint property or an annuity. Again, a lot of this has to do with looking at the planning that is done for government benefits and making sure that things aren't done inadvertently to kick somebody off of government benefits. So that's really in disclaim powers and powers appointments. So those are the superpowers. And, I pretty much have my clients sign all of them because the way that we look at it is I'd rather have everything in there and not have to worry about it in the future because we never know what somebody's going to come across.
Right. So at the very least, when we're talking about estate planning, at the very least, I tell everybody you need to have durable power of attorney. You need to have a living will, and which is nice to have it in writing.
Yes, it is.
What your feelings about what you want for your own self. And you also need to have the healthcare surrogate or the healthcare proxy. And those are the three documents that when someone is actually getting ready to move into an Arden Courts or any other dementia-assisted living, you're going to be asked for those documents. And they're necessary because as a durable power of attorney, that allows you to make the financial decisions for that person. Having their healthcare proxy allows you to make the healthcare decisions for that person. And that's what you're doing. You're making decisions for someone to move into an assisted living that has dementia because they can't make these decisions for themselves.
Right.
And they've given you their power, you're their healthcare proxy to make the best decisions for them within the scope of the documents. And when people come to me, a lot of times they don't have these, and I say, well, hopefully it's not too late that you can still obtain these because otherwise, like you said, they're going into looking at guardianship, which is costly, it's lengthy, it's more emotional, and you don't want to go that route if you don't have to.
Yeah, and it's interesting. So we were going back and talking about having to look back at your documents to make sure that they're updated. So just in the healthcare statute recently, The Florida statutes now say that it used to be your healthcare directives did not go into effect until you were incapacitated. So you'd be determined incapacitated, and then your healthcare surrogate could step in and make healthcare decisions for you. This was not in the place of, if you're terminal, that's different. That's your living will. This is a healthcare surrogate. So just recently it was passed that now those healthcare directives can actually go into effect immediately as well.
Without a person being declared incompetent?
Without a person. So you can sign, and it's an initial on the document, you can sign that your healthcare surrogate can also help make decisions for your illness or whatnot, even while you're capacitated. Although no matter what, if you're capacitated, your healthcare decisions rule. Your decisions are overrule anybody else's. But it's a good document to also have, because now, even though I might have a parent who's capacitated, well, they go to the doctor, they might not quite understand what's going on. Mm-hmm. Now I have a child that can go and help make decisions and whatnot.
And step in and actually get information, give information,
exactly.
Receive information,
help
regardless.
Make decisions for them and
mm-hmm,
whatnot.
Mm-hmm.
So it's again another reason why you need to look. And if you have documents from years and years and years ago, you really do need to have them looked at and make sure that they're updated.
Yeah, this is such good information. Are we done with the superpowers?
We're done with the superpowers.
Okay,
yeah.
superpowers with Super Heidi Friedman here, elder law attorney, board certified. Let's let everybody know, in case you've heard something you want to follow up on, you have other questions. Heidi, would you entertain people calling you and saying they heard you on the show
Absolutely.
And they had a couple questions, and how could they get in touch with you and set up maybe an appointment to further discuss their family situation?
No, absolutely. If you want to get in touch with us, our phone number is area code 954-383-1143. Our website is www.elderlawdepartment.com. Or you could always reach me on my own personal email at heidi@elderlawdepartment.com. So if you have a personal question, you can ask me directly.
Well, look here. You have direct access to the super-powered Heidi Friedman, elder law attorney. And I don't know many elder law attorneys or any attorneys are going to give you their personal email address. So, take advantage of it. She is a wealth of information. She is such a nice person, and you will definitely want to pick her brain and use her for your own superpowers. I want to thank you for coming in today. It's been awesome.
Thank you. Thank you for having me. I always have such a good time with you, Marcia.
Oh, thank you. I have a great time with you, too, and I hope you'll come back another time with us. Okay?
Absolutely.
And for all of you, please join us again, same time, same place. We'll see you next week. In the meantime, don't forget, call Arden Courts, 888-478-2410, and get your free 36-hour day book. This is something that we want to give to you as a thank you for watching our show, tuning in, and learning about caregiving, learning about Alzheimer's, dementia, and all the things that are related to it that a family caregiver needs to know. So do that. In the meantime, don't forget, give someone a hug, because they need it and so do you. Take care.
Thanks for joining us for this week's Caregiver Solutions with Marcia Teele. Join us next week as Marcia, who has 15 years of Alzheimer's disease and dementia care experience, brings you more needed information to help with the care of your loved one. This show can be seen again on caregiversolutions.info, and questions can be left on the site.